Welcome to Lawline. Lawline is a legal talk show hosted and sponsored by the attorneys of the law firm of Levin, Papantonio, Thomas, Mitchell, Exner, and Proctor. We discuss different legal topics on Lawline, and today we're going to do a continuing show in our continuing series on the BP litigation and settlement. My name is Mark Proctor. I'll be your host for today's show, and with me is my friend and partner Brian Barr. Brian, welcome.
Hey Mark, how are you?
Good. Brian and I are going to discuss today the BP litigation, the status of the litigation, the status of the settlement, and some continuing information and tips on what you need to be looking for if you or your business have experienced financial losses as a result of the spill, issues that you need to be aware of, and things that you need to be doing to protect yourself. Brian, as you know, is a member of the executive committee of the national litigation in New Orleans in the BP case, and he has been very, very involved on the national level, both in terms of the litigation itself as well as being one of the architects of this class action settlement that you've been hearing so much about in the press. Brian, let's start by giving our viewers the status of the litigation and what's gone on with the settlement. We've been hearing a lot in the press lately about the opt-out deadline and the fairness hearing. If you could explain to our viewers what those terms mean and exactly what's going on now.
Okay. Well, where we stand right now is the settlement program has been open since June 4th, and they've been processing claims since that point in time. I think right now there are approximately 70,000 claims that have been filed with the settlement program, and they've approved over $1 billion in payments in this point. So the settlement program is functioning, it's taking claims, and it's getting money out into the Gulf Coast, which is a good thing. We just recently had the fairness hearing in front of Judge Barbier. Because this is a class action settlement, you are required to provide notice to class members, and then there is a fairness hearing where people that object to the settlement can come in and state their grievances. For the most part, what we saw in the objections were people that were outside of the class area that want in. And so they really like the settlement program and they want to be a part of it. And that's just not the way it's structured. The other big objections were people, one of the defendants said BP was paying too much. That was Halliburton. So those were the types of objections, and that was the majority of objections. I mean, there were some people that stated some objections, but the court is going to consider those, and we expect him to have his order on final approval out shortly. And then that will decide whether or not this settlement works as a class action. And if he finally approves the settlement, then everybody within the class, unless they opted out, has to file their claim to the extent they're going to within the claims program. And so that's one of the very important things for people to start thinking about, because if you didn't opt out, this is your remedy. The most important thing, and it's something that we get a lot of questions on, is there are a lot of businesses and individuals with remedies that don't know they have a remedy. One of the things I tell people is don't think about this settlement in terms of did I or did I not lose money in 2010. This settlement, because of the impact of the spill and its wide impact on so many different types of businesses, the impacts on the coast affected everybody from the coast all the way up to the end of the county. It just had a domino effect all the way through. And so everybody is eligible to file a claim. And that's what everybody needs to do. Don't think in terms of I lost money in 2010. Just think in terms of, am I eligible for this settlement?
Now we hear a lot, and it is true that the oil spill occurred in the middle of the recession, and we hear a lot of comments from a lot of people about, well, I can't really say that my losses, if I had losses, were due to the spill. It may have been the recession. I don't want to do anything wrong. I don't want to pull the wool over anybody's eyes. Can you comment on those thoughts?
Well, that was certainly part of the settlement discussion, and what we ultimately decided was that there's a very important concept in the legal world called causation. And with causation, you have to come into court and show that your losses were caused by a tortfeasor, in this case, BP. What we tried to do in this settlement is, because there were so many different ways the dominoes could fall. You impact the store on the beach. Well, now their employees are making less money, so they're buying less food at the grocery store, and that impacts them, and that impacts their distributor and their supplier. It keeps moving up the chain. And so we didn't want to draw an artificial line somewhere. So what we decided to do was do it based upon a formula. And if you meet the formula, you're eligible for compensation. It doesn't matter, and nobody will ever ask, do you actually think your losses were caused by the spill? It's completely irrelevant to this settlement. BP agrees to that. The court hopefully will approve all of these processes. The court has certainly already preliminarily approved it. And we've seen the settlement program process and pay claims from the northern parts of Alabama for construction businesses, lawn maintenance people in the Huntsville area. So there's absolutely nothing wrong with filing the claim. It's what people are supposed to do. And kind of going back to your first question, dealing with the opt-out date, there's some confusion on that. That date was originally moved 30 days. From October 1 to November 1. So people had until November 1 to file their opt-out claim. All that means is that people that opted out are saying, I don't want this settlement, I want to go to court, and I'm willing to sit in litigation for as long as it takes and try my case, which could be 10 years from now before they ever get a trial. That's what those people want to do. Everybody else is in the settlement, and they have until at the earliest, April of 2014, to file a claim. So you have plenty of time to file a claim, get your documents together, have somebody look at them to see if you're eligible in the settlement, and file the claim.
Okay. So folks, this is very important. There are two morals to this story that Brian has just told us. Number one, the deadlines that you have been hearing about in the press for the last several weeks deal with that opt-out date, not the end of the settlement period. You have almost 2.5 years, as Brian says, at the earliest to file your settlement claim. The settlement time is not over. If you feel that you have losses, if you feel that you have been impacted by this oil spill, you have plenty of time to make a claim. Then on the issue of the claim, you do not have to know that your losses are due to the spill. You do not have to take the witness stand and swear on a Bible that your losses were caused by the spill. There has been a recognition in this settlement negotiation that we were in the middle of the deepest recession since the Great Depression when this oil spill occurred. There has been a recognition in these settlement negotiations that it would be difficult to prove causation due to the spill in court because of the interplay of all the other economic factors at work. And in lieu of that causation test, there have been negotiated into this settlement economic tests, which we're going to talk about in just a few minutes, that require that your business go down and bounce back up a certain amount within certain prescribed periods of time. And if you meet those economic tests, you are in this settlement. Whether or not you actually can testify to beyond a reasonable doubt that your damages were resulting from the spill, it is a matter of negotiation. The plaintiffs knew what they were doing when we negotiated this deal. BP and the other defendants knew what it was doing, and so you will be doing nothing wrong to have your claim analyzed. You will not be pulling the wool over anybody's eyes. You will be doing exactly what was intended by these parties to this settlement agreement, which is under the auspices and supervision of the United States federal court system. So you'll be doing nothing wrong. It's exactly what was intended.
And let me follow up on one thing, because I do want to add one thing about the opt-out date. When we talk about being able to file claims until April of 2014, that is for most businesses. So I want to make sure this is clear for anybody listening out there. Our commercial fishermen out there have 30 days until after the final approval, which could be happening any day now, to file their claim. And that's set up, the reason that way is because that is a $2.3 billion guarantee. That money is guaranteed to go out to whoever comes into the settlement program. And so there will be 2 rounds of payments. So we have to have everybody in to figure out who all is participating, so then we can allocate the money out fairly to everybody.
So if you are a commercial fisherman, you need to be getting to a lawyer immediately, because that final approval based upon the fairness hearing could come out any time. And as Brian says, you've got 30 days after that to file your claim. If you are something other than a commercial fisherman, then you've got this much longer period of time. But for both categories, your rights have not been extinguished by this opt-out period. That was only for people deciding they did not want to be in the settlement.
That's right.
So I think that's very important for everybody to take that away from this show.
Yeah, and just so people, I mean, I want people to really grasp this. We have seen farmers get approved for settlement in North Louisiana. We have seen hospitals. We have seen all types of businesses. And so please, if you are thinking about doing this and you're watching this show, don't think in terms of my business was not impacted. That is the absolute wrong way to be thinking about how to go about, making sure that you get what you're owed under this settlement.
And folks, lawyers are going to do this work on a contingency fee. Everybody that's involved in doing BP oil spill work is doing it on a contingency fee. And what's important about that is the evaluation and analysis is not going to cost you any money. Under the contingency fee system, the only way the lawyer gets paid, the only way the costs get paid by you, is if you actually make a recovery. So I don't want you thinking that, well, I don't have the money to get the case evaluated. It's not. The evaluation will cost you nothing. So if you reside in the class area, if your business is located in the class area, and remember, the class area are the Gulf Front counties of the state of Florida, beginning with Escambia on the northwest and running down the west coast of Florida, extending through the Florida Keys, the entire state of Alabama, the entire state of Mississippi, the entire state of Louisiana, and 4 coastal counties in Texas.
And we've actually got a slide we can put up and show people.
Let's put that slide up as we talk about it. If you reside in this class area, if your business is located in this class area, and it's on the screen now, you need to have your situation evaluated. Get to a lawyer. It will cost you nothing. That lawyer can take a look at your financials, your profit and loss statements, your tax returns, and determine whether you and your business will meet the economic tests that will allow you to prove up causation in the settlement. And then the second part of the evaluation is the calculation of damage. So please pay attention. If you reside or work or your business is located within this gray area on the map, you need to be looking at your situation and having it evaluated, because many, and I underscore the word many, of you will have a claim. You may not know it, but you will have a claim that is going to be funded by BP, and to ignore this or to not look at it is simply, as Brian said, potentially leaving money on the table.
Right, and just so everybody knows what you're looking at there, you're looking on the screen at a map of the zones. So the Zone A is yellow, Zone B is purple, Zone C is red, and then the gray is Zone D. It doesn't quite go down to South Florida, but we have another map that shows the entire class area, gives everybody a perspective of what it looks like without the zones. So there's the map that shows, you know, the whole class area, and as you can see, you know, this is a wide variety, a very geographically dispersed area. A lot of different types of businesses operate in Louisiana, Mississippi, Alabama, and these places in Florida. Sure. All of them are eligible except for a very small subset of excluded claims. Things like banks, insurance companies, real estate developers, they were specifically excluded. But that is, in the grand scheme of things, a very small segment of the types of businesses that are covered in that entire area. I mean, you are literally talking about the entire Alabama economy is eligible for payment in this settlement. Everybody needs to do their part here. I mean, the entire Gulf Coast has been hammered over the past several years by the economy, by hurricanes, by oil spills. This is the entire Gulf Coast's chance to get it back. BP is willing to pay the money. They are willing to pump billions into the Gulf Coast area, but the people that have these claims have to do their part and file the claim.
That's right. That's right. Very well said. Now I want to talk about the zones. We've talked about on previous shows the zones. We've got zones A through D, A being closest to the waters of the Gulf of Mexico, B, C, and D, as you can see on the map, as you move a little farther away. In Zone A, we've talked about causation being presumed. In Zone B, like downtown Pensacola, for businesses denominated as tourism businesses, causation is presumed. But I want to focus in for a few minutes, Brian, on zones C and D, because as our viewers can tell, C and D make up the very large bulk of the class area. Talk to us about what you've got to do in Zone C and Zone D to prove causation, and then kind of tell us where Zone C and D are.
Okay, well, I've got a slide that gives the causation tests. So you have up on the screen the different causation tests that everybody can try to use. And what you're looking at here is you're comparing any 3 consecutive months in 2010 from May through December to those same 3 months in either 2009, 2008 and 9, or 2007, 8, and 9 as an average. You're only looking at gross revenue. You're not looking at costs when you're doing this comparison. So the causation test itself is not that difficult to figure out. It's pretty simple to have somebody look at it, and with just looking at your gross revenues, your monthly profit statements, even maybe in some cases your tax returns, you can figure out whether or not you're going to be eligible to file a claim.
But let me interrupt you 1 second. Does it follow that you can't tell just by saying, I lost money or my business lost money in 2010? It's not that simple.
No, it's not. I mean, we have seen instances where a business, for example, was up $800,000 in 2010 as compared to 9, 8, or 7. I mean, $800,000 better than they'd ever done. And they ended up having a multi-million-dollar claim because you're looking at it in 3-month chunks. And they had a really bad 3 months in that 2010 and a really good 9 months. But those 3 months allowed them to be eligible, and they were able to file a claim and be approved.
So it's not something you're just going to do by looking at a couple documents in your living room.
If you ask the question, was I down in 2010, you're asking the wrong question, and you are going to walk away from a settlement that wants to pay you money. So,
excuse my interruption. Go ahead.
You are fine. So what you're looking at here is in Zone C. What you need to be able to show is that in those 3 months we're talking about that you were down 8.5%, and then looking in those same months in 2011 that you came back up 5%. That's the basic V-shaped test that we're trying to show. There's 2 other tests, the modified V and the decline only. Those are more difficult to meet. There's more documentation requirements on those. But, you know, fortunately now we've got plenty of time to try to figure those out. So even if you meet the modified and decline. Those decline only. Those are the only two you meet. There still are potential abilities for you to show that, and to show it's all financially driven. What's in your finances. In Zone D, for the only kind of little tweak is you need to be able to show some reason why you couldn't come back up, like a road closure or something like that. But those are things that people that understand this settlement can walk you through to make sure to give you your best shot of meeting causation.
Now, before we move to the economic test in Zone D, let's talk about the geographical area of Zone C. To kind of use the geography of Pensacola, let's say, Zone C is going to be much of downtown Pensacola all the way to Interstate 10.
Yeah, and there's a map on that, so if people want to follow along with Mark as he's describing
If
this.
you're familiar with the way Interstate 10 transects the Gulf Coast, much of the class area south of the interstate is going to be Zone C, except for the beaches, except for a portion of property in Pensacola Gulf Breeze, and as I said, a portion of downtown. So that financial test that Brian just described for Zone C is going to apply to anyone living or businesses located south of Interstate 10. As you move into Alabama, as you move into Mississippi, as you move into Louisiana, you also know that Interstate 10 transects those states. And so as a short form, the property south of Interstate 10, but not immediately on the waters of the Gulf of Mexico, will be Zone C. Now, what about the property north of Interstate 10? That's the large bulk of the class area. That goes from Interstate 10 to the northern county lines of Escambia County, of the state of Alabama, Mississippi, Louisiana. That is Zone D. Brian, tell us about Zone D.
Well, Zone D, the tests work exactly the same. It's just different numbers there. So, for example, in Zone C, it's 8.5% down. In Zone D, it's 15% down. And then they come back up. Zone C is 5%, Zone D is 10%. You're further away from the water, so you've got to be able to show a higher certainty of an impact during the relevant months. It doesn't matter why you suffered that decline. Completely irrelevant to the question. It's never going to be asked. Nobody's ever going to say, well, sir, why did you fall 15%? Doesn't matter. It just matters that you fell 15%. And then you came back up to 10%. If you did that, you're eligible. And we have seen numerous cases of the tens of thousands that have been filed of businesses in Zone D who meet that test and are being compensated millions of dollars. And that's why I keep talking about this is so important for people to pay attention to. It's really a chance for this area to recover.
It is, and it's very important for people to take a look at this. So kind of to summarize what you've said, if you are in Zone C, or your business is located in Zone C, and you can show that down 8.5%, back up 5%, regardless of why your business went down and back up, whether it's happenstance, whether there's another reason for it, you are negotiated into this settlement as a matter of causation. Is that correct?
That's exactly how it works.
And then in Zone D, the bulk of the class area, the place where many of you reside, where many of your businesses are located, if you are down 15%, as Brian described, and back up 10%, within the prescribed periods of time, regardless of what the reason is, regardless of whether it's happenstance, you are negotiated into this settlement as a matter of the settlement, and if the judge approves the settlement, as a matter of law. Is that right?
I think that's exactly right.
Folks, please be aware of this. This is important stuff. It's important to you. It's important to the Gulf Coast. you need to do nothing other than get your financials together. Your monthly profit and loss statements from 2007 through 2011, your tax returns for those same years, and if you're an owner or an officer of your business and receive compensation from the business, copies of your W-2 forms. That's all that you need to put together, and then let a professional look at it. Have your case evaluated by someone, by some firm that understands this settlement and can advise you whether or not you qualify for funds. There are a lot of misconceptions about the settlement. It's not over. The deadlines have not passed. You have time. If you're a commercial fisherman, as Brian said, you don't have a lot of time. You've got 30 days after the judge rules on this settlement, so you've got to act quickly. But for everyone else, you've got time. You've got time to get your financials together. You've got time to get them to somebody, make an appointment, have your case evaluated. The BP settlement can be the mechanism that will significantly bring our Gulf Coast back economically. Everyone has a responsibility to participate, and participation means nothing more than seeing if you qualify. There's nothing wrong with it. You're not doing anything underhanded. It is exactly what the settlement was intended for. Brian, anything to add?
No, I think you've covered it all, Mark, and I appreciate you having me on.
Thank you for being here, and stay tuned because Brian and I will be back on future shows to talk more about the BP litigation and settlement. Folks, it's important. Pay attention and have your claim evaluated. Thank you.